Welcome to New Possibilities. I speak truth to power without fear. Today I'm going to continue my discussion about the Mike Brown case and about the situation in Ferguson. Now, before I get into the discussion, I'm going to show you a video clip and then I'm going to show you a news article that I read, and I'm going to discuss both the video clip and the news article. So here, check out this video, and then we'll continue on the other side.
Was a criticism that of the prosecutor that you allowed witnesses, and I know you're not going to necessarily speak specifically on witnesses, but you allowed witnesses who you and your staff questioned their reliability, questioned whether they actually were there, had the right information. Their stories changed once they were questioned about it. Why did you allow people to testify in front of the grand jury in which you knew their information was either flat out wrong or flat out lying or just weren't telling the truth?
Well, early on, I decided that anyone who claimed to have witnessed anything was going to be presented to the grand jury. And I knew that no matter how I handled this, there'd be criticism of it. And so if I didn't put those witnesses on, then we'd be discussing now why I didn't put those witnesses on, even though, even though their statements were not accurate. And so my determination was to put everybody on and let the grand jurors assess their credibility, which they did. I mean, this grand jury poured their hearts and souls into this, and it was a very emotional few months for them. It took a lot out of them physically and emotionally. So, but I wanted to put everything on there, and I knew, I said, somebody would be critical of whatever I did, however I did it, even those who, first of all, we didn't release any information, and then we released too much information. And so, that just goes with the territory. But I thought it was much more important to present anybody and everybody, and some that, yes, clearly were not telling the truth. No question about it.
You don't do that normally, so that was something you did differently because of this case.
Correct. Yeah, the entire thing. Grand juries are not just. They also have some investigatory powers, and that's what they were. This was part of it here. It was in addition to presenting a case to a grand jury. They were doing some investigation. And so part of that is interviewing witnesses and bringing those witnesses in to testify and looking at documents and doing the like. So it was a lot different. Normally there's not, the investigation is done by the police beforehand, and then the information or the evidence is presented to the grand jurors in a more condensed fashion. But in this case, again, I thought it was very important. There were people, first of all, questioning whether I'd be fair or not. And so, to make sure that we were as open as possible, we presented it to the grand jury to let them make the decision. It's not as though we just, some of these pundits have said, we just opened the door and threw everything in and said, here, do what you're going to do. I mean, it was, if you've had a chance to look at even parts of the transcript and the evidence in the case, you can see how well organized it was, and it was all put before the grand jury in an orderly fashion, not some willy-nilly fashion. And they had the whole range, as a grand jury does, on every case as to any potential charges.
One of the criticisms was that Officer Wilson testified for a number of hours, and he testified that in a way in which he wasn't cross-examined. So his opinion and his story was told in its entirety, but Michael Brown didn't have a chance to testify in front of that grand jury.
Well, and obviously Michael Brown couldn't testify in front of the grand jury, but Wilson, any target, any suspect on any investigation, I would love to have in front of the grand jury, but we can't compel someone to come in and testify if they're the target of the investigation, if they're a potential defendant. And so in some cases we invite them to come in, and in some cases, in most cases, they declined. In this case, he decided to come in and testify, and believe me, I would take a sworn statement from a potential target on every case. I'd love to have that. We've had other situations in which, in fact, there's a guy being sentenced this morning, a former police chief from Charlotte, who was indicted by a grand jury for stealing from the city. Excuse me. And he was invited to come in and testify. He came in and testified, and the grand jury considered his testimony and indicted him. And then he was tried by a jury and convicted just recently and is being sentenced this morning. So it, sometimes they believe the individual, sometimes they don't. Sometimes it's, a little bit of everything. Just like any jury, they can believe all, part, or nothing of any witness testimony.
Criticism of you, Bob McCulloch, was that if you wanted to, you could have gotten this grand jury to bring an indictment. And I've asked you this before, and I'm going to ask you it again. And that is, you could have, as I'm assuming you do in certain other cases, where if you think someone's guilty, you sort of bring the evidence that you want to a grand jury so they indict. You didn't do that this time.
Well, we could have presented the evidence in such a skewered fashion to get anything that that anybody wanted out of there. If I'd put on just Dorian Johnson, they would have indicted him on murder in the first degree. But that wasn't the case, and that wasn't the whole case. And so this case was different, and it's not uncommon in a case where there are issues of whether it's legal self-defense or lawful self-defense or lawful use of force by a law enforcement officer. Those are issues that have to go in. If there's a shopkeeper who shoots a robber, that's information that's going to be put in there. This guy was robbing the store, and that's why the guy shot him, as opposed to just putting on evidence to say, hey, this guy pulled a gun out and shot this guy and killed him. My job is not to get an indictment. My job is to seek the truth and seek justice and do what is right and what's appropriate in there, and that's what we did in this case and all other cases.
When the decision was made and you made that statement, there was then video shortly after that has been released that Michael Brown's stepfather standing on top of a crowd. Anybody you're thinking about charging with perjury for going in front of the grand jury, calling you up, giving you false information, charging them with some type of perjury?
That issue has been raised, and it's a legitimate issue, but in the situation, again, because of the manner in which we did it, we're not going to file perjury charges against anyone. There were people who came in and, yes, absolutely lied under oath. Some lied to the FBI. Even though they're not under oath, that's another potential offense, a federal offense. But I thought it was much more important to present the entire picture and say, listen, this is what this witness says he saw, even though there was a building between where the witness says he was and where the events occurred. And so they couldn't have seen that. Or the physical evidence didn't support what the witness was saying. And it was it went both directions. There's talk of one witness now, and some of the media is doing exactly what I said they would do. They pull out one witness and just latch on to that. And this was a lady who clearly wasn't present when this occurred. And she recounted the statement that was, right out of the newspaper about, Wilson's actions, and right down the line with Wilson's actions, even though I'm sure she was nowhere near the place. But there were other witnesses, too, like I said. He said, well, I saw this whole thing, and even though there was an apartment building between me and where this happened, but I thought it was much more important that the grand jury hear everything, what people have to say. And they're in a perfect position to assess the credibility, which is what jurors do.
Do you think that the grand jury gave that witness any credibility when she went up on stand?
No. None whatsoever. I mean, it was perfect. The one thing that changed in her story several times is the reason she happened to be in Canfield that day. She changed that, but she never did change, her description of what she claims to have seen.
That's
just not right.
Is there anything, Bob McCulloch, that you wish you would have done differently?
We will dissect this as we do with a lot of things, and look back and see what what can be done or what we could do. And at this point, there's not a whole lot. Now I probably would have spoke out more about, particularly when people were talking about, my inability to be fair because of my background. My father was a police officer killed. What they ignored, and this tells you just how opportunistic some of the politicians were in doing that, is that what they ignored is that on the 5th of July, about a month before Michael Brown was killed, a Pine Lawn police officer shot and killed an unarmed man. And what Pine Lawn did was immediately call the St. Louis County Police and ask them to handle the investigation, which they did. They ran that investigation. They completed it in mid-October of this year, and they presented it to me. And we reviewed everything. One of my prosecutors did. My chief investigator reviewed it. I reviewed it. We then had the police do some additional investigation on it, and then completed everything and released the information. We looked at it and made a determination that it was indeed a tragic, yes, but a justified use of force by a law enforcement officer. We provided that information back to the county police department, of course. But
Okay, so you saw the video. Now I'm going to proceed to discuss this news article that I read today. And, I read a couple of days ago and I reread it today, looked over it today. So this article is about witness number 40, and her name is Sandra McElroy. Now, this article points out how this woman basically just made up a story about what happened on the day Mike Brown was killed. This woman was not in the area at the time of the shooting. She did not witness the killing of Mike Brown. But yet she made up a story. She made up the story that Mike Brown attacked the officer first. She made up the story that Mike Brown turned around after he was running from the officer, that he actually turned around and charged the officer like a football player. She just made that story up, basically to justify the killing of this young black teenager. And that's only the beginning of the problem. This article points out how this woman has a history of committing crimes. She has a history of being bipolar. It also points out how she is a racist. How she's made statements that are derogatory about African Americans. She's referred to us as niggers. She basically implied that we're less than human in some notes that she made, where she said, well, I want to visit the black community so I can learn to stop referring to black people as niggers and to start seeing them as human beings. That's what she actually said. That's what she wrote down in one of her journals. Not only that, this woman has a history of supporting Darren Wilson. She supported him in social media. She's posted objectionable and sickening photos and statements on social media in support of this killer, Darren Wilson. And one that stands out in particular is this photograph here. It's a photograph of Mike Brown laying in the street dead with blood flowing from his head. And the caption says something to the effect of, don't ask for justice for Mike Brown, or stop asking for justice for Mike Brown, because justice has already been served, basically. And she's implying that this teenager deserved to die. That was the implication of her statement. And even worse than all of that, even worse than the fact that this woman lied, that this woman is a racist, that this woman is a Darren Wilson supporter. Even worse than that is the fact that the prosecutor knew that this woman's testimony was false. They knew that she was inconsistent in her statements. They knew that she had no credibility whatsoever, but they allowed this woman to testify. They allowed it. And this interview points out how the prosecutors knew this, but they had no problems with bringing witnesses before the grand jury that they knew were falsely testifying. They knew this, but yet they allowed these witnesses to testify. And that is a violation of ethics rules. There are model rules that say that attorneys should not allow witnesses to falsely testify. They should not present witnesses before the court who they know are making false statements or falsely testifying. That's a violation of ethics. And as I talk right now, I'm showing you clips of or photographs of segments of the model rules for ethics that attorneys are required to abide by. In the legal profession, we have a code of ethics that we have to abide by. And one of those codes deals with false testimony. And clearly, it appears that the prosecutor violated that most basic rule, that you should not allow witnesses to testify if you know that they are falsely testifying. That is very problematic. And it is just a reminder of what everyone had been saying before this case had gone before the grand jury. And that's that this prosecutor was biased. And one thing that stands out about this interview is the fact that this prosecutor says that no charges will be brought against any of those witnesses who falsely testified, including witness number 40. And that is a disgrace. That's a shame that they would freely allow these witnesses to falsely testify before the grand jury. A witness whose statements are critical, whose statements basically validate or, attempt to validate Darren Wilson's story. And for all we know, it's very possible that witness number 40's testimony may have swayed the grand jury to not indict Darren Wilson for the killing of Mike Brown. That is a very real possibility. And for this prosecutor to just brush it off as no big deal and to just assume that the grand jury didn't take her testimony seriously or that they did not credit her testimony, that's outrageous. There should be a thorough investigation of this prosecutor. There should be an investigation to determine whether or not this man violated the rules of ethics for attorneys. And if that's the case, he should not only lose his job, he should lose his law license, or at least be suspended from practicing law for a certain period of time. Now, during this interview, this prosecutor admitted that he does not normally just present all the evidence. He does not normally just present witnesses before the grand jury that he knows are going to falsely testify. He doesn't. He admitted that. So the question is, why would he do so in this case? And for me, the answer is obvious: because he never intended to prosecute Darren Wilson for the killing of Mike Brown. That was never his intention. This man basically acted as the attorney for Darren Wilson instead of the prosecutor of Darren Wilson. And during this interview, this prosecutor acknowledges that he did not cross-examine Darren Wilson. He just allowed this man to talk. There was no tough cross-examination or tough questioning for Darren Wilson. He was handled with kid gloves. He was given softball questions that basically made it possible for him to be viewed in a good light, or for his testimony to be viewed in a positive light. And that is despicable to me. That's outrageous. Here we have a young black man dead, and they didn't seriously question the killer. That's outrageous. And during this interview, this prosecutor acknowledged that he could have easily got an indictment of Darren Wilson if he just presented, for instance, Dorian Johnson's testimony and left it at that. He could have gotten an indictment just based on Dorian Johnson's testimony. But clearly, his goal was not to get an indictment. He did not want to indict Darren Wilson. He did not want him to be convicted. And that's obvious by everything that he did that was out of the norm. It's really outrageous. It's sickening, that this prosecutor would allow this to happen, that he would allow this killer to walk free by presenting all of the possible evidence, testimony from witnesses that he knew were falsely testifying. He just allowed any and everything to go before the grand jury. And that basically probably confused the grand jury and made it so they reached the decision that they reached, the decision not to indict this killer. So now we have this killer walking around free, this killer making thousands upon thousands of dollars, basically profiting from the death of this young brother. This is outrageous. And see, what has happened here is instead of having the normal grand jury process, which is basically designed to determine whether or not there's probable cause for the accused to be indicted or to be charged. Instead of that being the case, they had what amounted to a trial, but it was a trial in which the killer was allowed to just say whatever he wanted without any kind of real examination, where any and every witness who just made up stories was allowed to testify before this grand jury. This is outrageous. Not only should we be calling for a thorough investigation of this prosecutor, we need to demand that governor appoint a special prosecutor to investigate this case again and to pursue the case again, to charge and to indict this killer, Darren Wilson. We shouldn't rest until there is a new indictment of that killer, Darren Wilson. Because who knows what's going to happen with the federal investigation? Who knows? They said that there was going to be a federal investigation of Trayvon Martin. That process is still continuing now. But to date, we have not received justice for Trayvon Martin. And we probably never will. Our last chance for justice, our real last chance for justice is to demand a special prosecutor be appointed in Ferguson to pursue charges against that killer, Darren Wilson.